Hello to Facebook, happy Friday. My name's Jackie Broman, obviously from TBA Law. Once a month we do a Facebook Live information session on here, and in the events on our page you'll notice what the upcoming ones are. In July we've got one coming up on the changes to conveyancing. There's often a lot of changes that come in on the 1st of July. But today the topic that was advertised was estate planning, aged care and elder abuse. So, sorry I'm about 15 minutes late. I just had to wait until the room was available for me to be able to get in front of the camera. So, estate planning specifically focusing on people who are, I suppose, more elderly, needs, I suppose, to be done gently. So the first thing as a solicitor that we always think about when someone who's elderly is brought in, usually for their estate planning to be done, is capacity. So quite often at this stage there's only one of the couple left. Potentially they separated earlier on in life, so it's either mum or dad coming in, and it's usually one of the kids that are bringing them in. Sometimes it's a friend that's bringing them in. So what do we have to think about first, like I said, is capacity. So, and we also have to protect the person themselves and their wishes. So we want to make sure their wishes are going to stand up. So the children who are bringing their elderly parents in need to understand that as solicitors we need to see and get the instructions directly from the person themselves. So that often means excluding you as the child from the room where we're getting the instructions. Now, quite often as well, if someone is quite elderly, we will also ask them to go to their doctor and bring a medical certificate saying in that doctor's opinion whether they have capacity to make testamentary decisions. Doctors are quite used to doing these things. Sometimes if someone's in early stages of dementia, it could be a little bit borderline. We might have a mini mental test done, and so we have the result from the mini mental. Or sometimes we even ask that the person be sent off to a specialist, and we actually have a more thorough assessment from a more qualified person than a GP to make the assessment. Quite often, if the elderly person has been seeing the same GP for years and years, I'm fairly comfortable that that person can make potentially a better assessment than a specialist that they've only just seen, because the GP will have spoken to them and will know far more about them and what they were like prior to how they are now, so potentially has a better understanding of any level of decline that there might be. So for the elderly, the first thing at the front of our minds is their capacity. We want enough evidence that there is capacity so that the person's wishes can stand up, and also we don't want any other beneficiaries being able to claim that there's some kind of undue influence, which is also why we want to see the person alone. We don't want anyone to say that there was anyone influencing what they said. So those are the first things that are at the forefront of our minds when someone's brought in to do their estate planning. We then go through in fair amount of detail what the family tree is, what the personalities are like in terms of their kids, what the relationships are like, what the interaction between the kids are like. We ask the person as well what they own. There is a legal test to capacity that we are thinking about in the back of our minds, and the elderly person actually does need to have a fairly good understanding of what they have as one of the tests for capacity. So we ask them about who they bank with, how many accounts they have, do they still have real estate, what else they have. And then we get into instructions for the will and powers of attorney. Often it's really, really helpful to have any previous wills, so we can also see potentially how much their instructions are diverging. Sometimes that can be a red flag for us, but if the person themselves can provide really clear instructions as to why they're making such changes, it's really good for us to have that in our notes as well in case there is a challenge to the will later. Powers of attorney are really important too, and that's really what I wanted to focus on today, is around powers of attorney, because I think that there are potentially a lot of risks around powers of attorney, but they're almost an essential thing that we need to have as well. The laws have changed over the last 4 or 5 years a fair bit in this area, which has actually tightened up some of the elder abuse stuff that was happening in Victoria. So we are, I suppose, ahead of the curve in some respects, but there's still potential there for elder abuse to happen. Now, elder abuse doesn't just have to be financial abuse. It can also be isolating the person. It can be causing anxiety in the person. So elder abuse is also something that is at the forefront of our mind when we're thinking about powers of attorney. And we want to also make sure that the people who are appointed under the power of attorney know what their obligations are. So it is now illegal in Victoria, it's a criminal offence for an attorney to steal funds essentially from the person who's appointed them, to act in a conflict situation where they're benefiting. So previously the police used to have to try and prove a fraud case, which was really quite difficult, but now they don't have to. And VCAT actually has a whole lot more powers that have been given to them in terms of being able to call in the attorney to account for what they've done, and also to have them investigated and potentially have orders made for the recovery of funds that they can't account for. Now, having said all that, it's something, I suppose, for attorneys to keep in mind. So if you've been appointed as a power of attorney for your elderly parent, it's good to review them. Okay, there are some risks around some of the older powers of attorney, but the biggest risk, I think, arises when a power of attorney begins immediately. Now, I try not to have the powers of attorney begin immediately unless it's really necessary. It's best that they don't begin until the person has lost capacity. However, if they do begin immediately, the attorney has to be really aware that the person themselves can still do things for themselves, even though the powers are current for the attorney as well. Now, we had a situation here a couple of years ago where someone was appointed under a power of attorney, but his mum was still fine. So she was still doing things for herself. She was making gifts to various family members. She wasn't keeping track of these things. She wasn't recording any of them in writing. And she was giving gifts to the attorney as well. Now, the family was really fractured, and later on the family claimed that the attorney actually stole the money from his mum, that he couldn't prove that it was given to him. And unfortunately, he couldn't prove it, even though he said that, no, she absolutely wanted to see him have some benefit while she was alive. Problem was, he was the only one with a power of attorney. All the other gifts that she made were fine, but for him, receiving gifts from her under a current power of attorney was a conflict of interest. And so VCAT did actually make an order that he repay funds into the estate, quite in a substantial amount too, which has been devastating for him and his family. So powers of attorney, or people appointed under a power of attorney, so the attorneys themselves, have to be really conscious of this. Check whether the power of attorney actually begins immediately, because as soon as it begins, you have additional roles and responsibilities and obligations to make sure that there is no conflict of interest. So even if the person is okay and they're giving money to your family, to your children, and it's not recorded anywhere that they're doing this, it is a conflict of interest for you under your power of attorney. Now you can see as well how if a power of attorney begins immediately, it also raises risks of elder abuse. There was another case that I came across again where if a power of attorney had begun immediately, there were actually two people appointed as attorney, but they didn't have to act jointly, so there wasn't that extra level of protection, which you can have as well. If you have two people that have to act jointly, there is that extra level of protection. But these two people were appointed under a power of attorney by their mum. One of them systematically started, she had a gambling problem, unfortunately, and she was accessing her mum's funds, and she gambled, hundreds of thousands of dollars away. Now, it wasn't until the other power of attorney picked up on this, the other one wasn't actively involved, particularly because the power of attorney began immediately and their mum was actually still fine. So it wasn't like the other woman needed to be involved yet. But when she found out, how little funds were left, inquiries started to be made, and there were consequences. Unfortunately, there was no way of recovering the money because it had been gambled away. So it's inadvertent elder abuse in that case. It wasn't, I suppose, like I said, overt on the person themselves, but the person now has far less funds. It was an abuse of the rights and obligations for the attorney under that power, and there were consequences. So I suppose that's all I really want to say around making sure you get the powers of attorney right. So preferably they don't begin until the person loses capacity, and then the attorney needs to be aware of what their obligations are, to make sure they don't mix funds, to make sure they keep proper accounts, to make sure there's no conflict situations. So those are the main things. They have to act in the best interest of the person they've appointed. They can't benefit from the appointment. So it can be quite a burden, a power of attorney. So we've covered off what we as solicitors check when we have an elderly person brought in to do their documents with us. We want to check on capacity, and we want to make sure that we minimise the availability of a claim of undue influence by the family. I've talked about getting powers of attorney correct and the potential there for elder abuse claims, rightly or wrongly, and also about attorneys making sure they protect themselves against an elder abuse claim. The next thing I wanted to talk about was aged care and some different options there, I suppose, for someone elderly thinking about where they're going to live. So for many, many elderly people, there is the resistance to leave the main house. There is a myth among some people that if you hold on to the house, it's less likely that it can be counted as an asset that then requires to be sold to get them into aged care, right? So that's not a rule that applies. And besides, the bond that's paid into aged care comes back anyway. It's not like it's paid and then it's gone. So if the elderly person is worried about leaving inheritance for their children, which is another thing altogether, that shouldn't be their foremost worry. But if they're concerned that they want to make sure there's something left for their children, it doesn't have to be a house that's left. The deposit bond that is paid into aged care, so whether that's a few $100,000, will be paid back to the estate. So there's always going to be money still in that scenario. A couple of different scenarios, I suppose, are available, and people really need to Get advice from Centrelink as well if there's age pensions involved. But also, there are specific financial planners who help people go into aged care. So recently I had someone come in who had advice from a solicitor who I would argue would be the wrong person to ask this of, whether the house would have been assessed as part of the aged care assessment for assets. Now, that's a financial question. Solicitors don't necessarily keep on top of the legislation around the financial rules of getting into aged care. So in this case, in fact, because one of the children had moved in with the elderly person and had been living with her as the carer for a number of years, the asset was a protected asset because that carer was continuing to live there, and the solicitor had given the incorrect advice. So just be careful. You need to seek broad advice and from the right people. So solicitors can help with, like I said, estate planning documents, but not necessarily financial assessments about planning to go into aged care. You do need to talk to Centrelink, talk to a financial planner about those sorts of things. Now, granny flat arrangements are something that I wanted to touch on because it's an interesting arrangement, and Centrelink recognises granny flat arrangements. So where an elderly person sells their house and pays a bond, they're essentially paying the facility to accommodate them and look after them. So an elderly person can do the same thing to their family. They could, if they have to, sell their main house and move in with a child and either buy a granny flat to put on their child's property or improve the existing house. So build on an extra room or and an extra bathroom, or make upgrades, for wheelchair and upgrade bathrooms, etc. Now, it firstly is a way of getting assets down for the asset test for a pension. So if there is an issue where someone sells their primary residence, and because they now have a lot of cash assets, their asset test changes and they might be pushed down to a part pension. This is the one way where someone can get around gifting rules with Centrelink, is under a granny flat agreement to give away, essentially, or improve the value of a child's property in exchange for their promise to care for their parent. Okay, similar to paying a facility a bond to go in, which is a payment for them to care for you, you can pay a child by improving their property, and Centrelink recognises that. We like to document that in a granny flat agreement, a proper one, so that it's nice and clear to Centrelink, but Centrelink often can look at a situation and realise that a granny flat arrangement is arising anyway. So that's an alternative, I suppose, to aged care that people can consider. And look, the other thing around aged care is that people need to be getting their aged care assessments early, even while they're still at home, because if they get an aged care assessment, the assessment will say what services are available to them based on their needs. It doesn't matter if they don't access those services, but it means that the assessment is sitting there just in case they do suddenly need those services. It's a horrible situation for someone to decline suddenly and not have an assessment ready to go with services available to them, and then they're having to wait potentially weeks for an assessment. So have the aged care assessments done early, particularly if they're staying in their own home, because sometimes the assessments will say they're eligible for some funding for improvements to bathrooms with handrails, etc. They might be eligible for someone to come in once a week. If they don't access that straight away, that's fine, but it's there ready to go. They might be eligible for respite care. Again, they might not want to use that respite care yet, but it's there just in case the person who is most caring for them suddenly wants to go on a 2-week holiday and they can't be there all the time. Mum or dad can go into respite for a couple of weeks, and the person can go away knowing that their parent is fine and not at home without someone looking after them. So aged care assessments are really important. Under aged care assessments, the priority is to try and keep people in their home as long as possible. So there are a lot of services around keeping people in their own home. When someone comes time to go into aged care, I really do want to reiterate that it's important to have proper financial advice. There are a number of different ways where people could go into different facilities. Some are more like retirement villages. So it's older people living in a community. There are about 3 or 4 different kinds of legal arrangements that can arise in, giving people different rights. So that can be something that someone can come to a solicitor for advice around. If they're going into a retirement village, do they own their land title, or do they only own the building? Are they only on a long-term lease? Is it a arrangement where they actually own shares in a management company? So these are all the things that need to be looked at. And also, if they can't stay in that retirement village, either they pass away or they have to go into a higher care arrangement, what are their rights to sell their own property directly, or is it have to be sold by the company or management facility? And what's the percentage that retirement village takes at the time that it's sold? So retirement villages could be a step between someone staying in their original home and actually going into a higher care facility. In the aged care facilities now, there used to be high and low care. It's still easier to think of it that way, but in terms of funding, they no longer call it that because they're funded on a different means now. But aged care facilities still practically operate on a high and low scenario in a lot of situations. So you'll have people who are in a retirement village but quite physically capable still, quite mentally sound, but they have a room where they have a nurse that can check on them regularly. Their medication's probably given to them daily rather than having to manage their own medication. They obviously get meals. There's activities that are organised. They have their washing done for them. They could have their own bathroom or a shared bathroom. So in a low care situation, it could be more of a hotel kind of scenario sometimes. So I suppose that's the next level up from a retirement village. Some retirement villages offer emergency alarms, but the level of care that the maintenance company provide is probably limited to that. And the person needs their aged care assessment to have external people coming in to the retirement village, to their residence, whether it's Meals on Wheels or it's a nurse visiting 3 times a week to help them with their cleaning up or, showering once a day or whatever. So, again, even in a retirement village, similar to someone being in their own home, they have access to all sorts of external services, under aged care assessments. So you're looking at staying in your own home with aged care services. The next step might be a retirement village, and you can have those services come to you there as well. Or the next step up would be like a low care arrangement in a residential facility, or then level up from that is then where you're looking at high care, usually where someone is in bed the majority of the time, or they no longer able to clean themselves properly, those sorts of things. So again, important thing to remember is that bond that you pay to go into a facility like that is refundable. There's all sorts of rules about that. They have to pay interest if they don't refund it in a particular period of time. You don't have to pay a bond in all scenarios. There are a lot of places for people who have no assets, and the government subsidises a lot of that. There's caps on the amount of fees that have to be paid over a period of time. So again, you want financial advice around this. And people can actually go in, like I said, without paying a bond and just paying a daily rate. Now the daily rate would be quite high in that scenario, but some people are able to do that and want to preserve what real estate they have potentially. So there you go, a whole lot of information. The video I will post, although it's live at the moment, so it'll be on the page if you want to come back to it. You can tag people's names in it if you think it's important information to you, but because it's posted there, you can, speed forward to the part that's most important to you. So we covered off firstly what the important things are around financial estate planning when someone comes in to see us. We're thinking about capacity, we're thinking about undue influence claims, and we're thinking about how the powers of attorney are going to operate, how elder abuse might play in, and making sure that the attorneys have the advice around their role and obligations. Then I started talking about arrangements for as people get older. The granny flat arrangement is something that's available and should be looked at. I expressed the importance of having a financial planner and getting proper advice, particularly from Centrelink as well. And then I talked about the options, I suppose, for aged care as someone progresses or ages that can be considered, but again, focusing on the importance of having an aged care assessment as early as possible, so that that's in place even if the person's still in their own home initially. So I hope that that was helpful. I hope that it was information that you can come back to when it's relevant for you. And of course, if there's any specific questions that you have, you can direct message us through Facebook. We will get back to you sort of within a 24-hour period. Jump on our website too. The link is on our Facebook page. It's just tbalaw.com.au. All our email addresses are on there, so you can find us there. There's also an inquiries form that you could submit with a question if you want, and that's emailed to us. So if you do have a question like that, then please do reach out to us. If you want more specifics and you actually want to bring in your elderly parent, or you want to have a chat to us prior to bringing your elderly parent in, initial appointments are generally $295. So please reach out and make that appointment if you need to. The fee is capped at that if you don't proceed. If you do proceed and some documents are done, quite often we roll it into a standard cost that covers all the documents and things that we're doing for your parent anyway. So I suppose I hope that eliminates any worry there about cost. So